This is Barry Zalma on insurance. I am an attorney who has retired from the practice of law and now spend my time as an insurance claims consultant and expert witness, an author and producer of these videos. Today I'd like to talk about what mold inspections cannot do, rather than what they do in fact. The commonly used testing methods for mold infestations are limited in what they can detect and measure. Many people have unrealistic expectations of what mold testing can do, and they can be taken advantage of by those who perform testing poorly or for inappropriate reasons. When dealing with emergency services, that is, loss mitigation people, restoration, construction, or mold containment, the vendors of such services should understand that the industries they serve are in business to provide for safety to life and property and protection of human health. When mold is discovered during the evaluation or drying process after a loss where water escapes into a building or where there was a fire and the water suppression infested the building and was not totally dried out, steps must be taken to protect the health of workers and occupants within the structure, as well as preserve the structure from further damage. There are no federal or state regulations for loss mitigation, restoration, or mold remediation industries. Restoration vendors who wish to maintain a professional organization in which the public can place its trust should institute an internal educational and certification program for all its employees. When retaining the services of a restoration vendor, the person making such a retention should make inquiries to confirm that it educates its employees continuously and that they are well trained in the removal and protection of the public, removal of mold contamination and protection of the public. Restoration vendors should be able to show customers that they have developed an in-house training program on the use, storage, maintenance, and safety practices of all company-owned or rented equipment and all testing procedures and supplies, as well as on their quality control and assurance program. Restoration vendors should have their technicians and managers trained and certified on the Code of Federal Regulations, safety and health programs, and certified with the Federal Insecticide, Fungicide, and Rodenticide Act when required by law. Project managers, fire water managers, and the company's QC&A managers should receive certified restorer certification and water loss specialist certifications. When estimating, evaluating, or drying losses that involve water, the remediator needs a complete understanding of how structures are built. It is essential to understand airflow in structures, what water intrusion can do to a structure, and its components, and how water flow and humidity work in the structure. In some states, the remediation provider may not be able to obtain payment for the services provided if they are not appropriately licensed. For example, in Louisiana, Tradewinds Environmental Restoration entered into a contract to provide mold remediation services without a license. the action was specifically prohibited by laws intended to protect the public interest, and the contract was therefore ruled absolutely null and void. Tradewinds was only allowed to recover its actual cost of materials, services, and labor, but was not entitled to an allowance for profit and overhead. Although this was a harsh result, the purpose of the licensing statutes is to protect the public. In some states, the unlicensed contractor is not even allowed to collect for the reasonable value of their services. Consider Arizona's Statute 33-981 and California Business and Professions Code Section 7031. For example, in California, a court found, quote, "The purpose of the licensing law is to protect the public from incompetence and dishonesty in those who provide building and construction services. The licensing requirements provide minimal assurance that all persons offering such services in California have the requisite skill and character, understand applicable local laws and codes, and know the rudiments of administering a contracting business." Section 7031 represents a legislative determination that the importance of deterring unlicensed persons from engaging in the contracting business outweighs any harshness between the parties, and that such deterrence can best be realized by denying violators the right to maintain any action for compensation in the courts of this state. Close quote. This was Hydrotech Systems versus Oasis Water Park, a 1991 decision of the California Supreme Court. A competent and honorable contractor will not perform services for the public without first obtaining a proper license. Failure to acquire a license can deprive the contractor of valuable rights. Retaining the services of an unlicensed contractor is also hazardous to the property owner, since there is no assurance of competence and a high potential of litigation between the property owner and the unlicensed contractor. Further, if the unlicensed contractor or his employees are injured on the scene of the work, the property owner is obligated to pay workers' compensation benefits to that employee of the unlicensed contractor, or to pay tort damages if workers' compensation benefits are not available. With regard to the containment of mold infestations, the EPA has stated that the purpose of containment during remediation activities is to limit release of mold into the air and surroundings in order to minimize the exposure of remediators and building occupants to mold. Mold and moldy debris should not be allowed to spread to areas in the building beyond the contaminated site. Mold containment barriers should be placed beyond the mold formation using methods that do not disturb the mold formation. Mold remediators recognize that some mold spores release explosively when disturbed. Restoration vendors not trained or certified in mold remediation should refrain from removing mold at any level, even when requested by the occupant, the building owner, or an adjuster. Now, some certification is available for restoration vendors that perform emergency services like water loss drying, and can obtain mold remediation certification from the American Indoor Air Quality Council, the Indoor Air Quality Association. Restoration vendors and their technicians can obtain water damage certification from the Restoration Industry Association or the Institute of Inspection, Cleaning, and Restoration certification. Restoration vendors can join and get involved with professional restoration contractors associations such as the Restoration Industry Association, the British Damage Management Association, the International Society of Cleaning Technicians, or the National Institute of Restoration. In addition, the U.S. Code of Regulations provides guidelines for mold and fungus testing. For example, it states, quote, fungus resistance. A fungus resistance test or analysis must demonstrate that a component satisfies all its performance specifications after being subjected to fungal growth environment. Any analysis must demonstrate that all unsealed and exposed surfaces do not contain nutrient materials for fungus. This is 14 CFR .417 Appendix E in the Aeronautics and Space chapter. In addition, the regulations regarding testing of mycology for Medicare and Medicaid services require types of services offered by laboratories. In mycology, there are 4 types of laboratories for proficiency testing purposes that may perform different levels of service for yeasts, dimorphic fungi, dermatophytes, and aerobic actinomycetes. Program, content, and frequency of challenge is to be approved for proficiency. Testing for mycology, the annual program must provide a minimum of 5 samples per testing event. There must be at least 3 testing events at approximately equal intervals per year. HHS approves only those programs that assess the accuracy of a laboratory response in accordance with certain paragraphs of the regulations. In 2003, the Florida State Senate prepared a report recommending statutory control over mold remediation companies, and these statutes came into force in 2011. This video was adapted from my book, Zalma's Mold and Fungi Handbook, which is available as both a Kindle book and a paperback from Amazon.com and from my website, Zalma.com, by clicking on the link to the Insurance Claims Library. If you found this video to be of interest or useful to you, please forward it to your colleagues. It's free. And please subscribe to my Rumble channel and my YouTube channel and my blog so that you can learn about future videos and blog postings. Thank you again and again for your attention